Good afternoon, everyone. Thank you so much for joining us for this back-to-school webinar on residency and homelessness. For those of you who are not familiar with Franczek PC, we are a Chicago law firm of approximately 30 attorneys representing schools all over the state in the full range of education, labor, and employment law issues. Before we get started, there are just a few housekeeping items to address. First, right under the presentation slides, you have the ability to type and submit questions. Please feel free to ask questions throughout the program by using this feature. Everyone logged into today's program will receive an email that includes a link to the recording of the webinar, as well as a copy of the presentation. Now let's get started. My name is Jackie Wernz, and I'm joined today by two other partners here at Franczek, Amy Dickerson and Kendra Yoch. Amy, Kendra, and I have been fielding many questions on residency and homelessness from clients over the past few weeks, and so we're very excited to share some of what we've been seeing with all of you today. Before we get into the nitty-gritty, why are we even doing all of this? Why do we care about residency and homeless eligibility? It's not fun telling a family that their student can't attend a particular school or district, so why be so strict? We're doing this because state law says that only students who are valid residents of a school district or who are an eligible homeless student are allowed to attend schools tuition-free in that district. And if we can avoid enrolling students in the first instance who are not eligible to attend school tuition-free, we can save ourselves a lot of time, trouble, and money. That's because, as I'm sure we all know, students can be excluded from school more easily if it happens before the first time they enroll than they can once they have already been a student. And this is vitally important if we want to avoid costly investigations and dispute hearings that are necessary to remove a previously enrolled student under the residency process. Another goal we hope you keep in mind today is that we want to make sure that we avoid providing legal advice to or interpreting the law for families. We are going to be talking a lot about the law today, and we should and often do have conversations between ourselves and the legal team to talk about whether a person has legal rights to enroll a student in school. But it's not our role to tell families what we think the law does or does not mean, unless it's in a formal written communication to the parent, such as a letter or a notice of dispute. We can and should feel free to direct parents to resources such as ISB for residency and homeless questions. Finally, we want to always keep in mind our responsibility to avoid violating the robust rights of homeless students. We have to keep this in mind at all times, even if a family does not say the word homeless, because as we will see when we discuss some recent dispute resolution proceeding decisions, ombudspersons are not taking it easy on schools when they feel that they are not sensitive enough to the robust rights of homeless students. So let's start out by talking about regular residency issues. And let's do so through a hypothetical student, Allison. Allison is a general education student, meaning that she doesn't have any special education needs. She doesn't have an IEP. There is no claim of homelessness, and there are no facts suggesting that Allison is homeless. Her mom, who comes to enroll Allison, provides documentation that they own a home in the district, and she also has copies of current electrical bills. But here's a twist. Mom makes a comment at the time of enrollment that, oh yeah, we moved into this district because the schools are so great. We're so excited to have our kids attend the district schools. So let's talk about, is Allison a resident of your school district? And when we're breaking down that question, we're going to look at, for general education students, where the student's legal custody lies. Who has legal custody over the student? And legal custody is a term that has a different meaning with respect to residency than it might when we use that word more generally out in the world. It has a very specific meaning in that it's one of the 5 things that's identified in the school code as legal custody. And we have those listed here. And the goal for a school is to decide which one of the 5 situations most clearly reflects the reason the student lives in the district or where the student is living. So number 1, the most obvious case, is if the student lives with his or her natural or adoptive parents. If that's the case, the student is a resident of the school district in which his or her natural or adoptive parents live. Number 2 is if a court has granted custody to an adult with whom the student lives. In that case, the pupil is a resident of the district in which that adult lives as long as the pupil is not living with the adult for access to educational programs of the district. Note that this is court-ordered custody, not guardianship, and usually there's going to be documentation from a court or the state to show that this transfer of custody has occurred. Number 3, if an adult has been granted short-term guardianship, then the pupil is a resident of the district in which that adult lives as long as the pupil is not living with the adult for access to the educational programs of the district. An adult's written appointment of short-term guardianship is sufficient to enroll a student, so long as there's no question that the student is living in the district for some reason other than accessing your schools. The adult is technically required to obtain a court order granting permanent guardianship within 60 days. However, failure to do that cannot lead to disenrollment of the student, so it's not really all that relevant. Under number 4, if the student lives with an adult relative caretaker receiving aid under the Illinois Public Aid Code for the student is a resident of the district in which that adult lives as long as the student is not living with the adult for access to the educational programs of your district. Again, there is going to be specific documentation that the adult can show to prove this. Finally, the catch-all, number 5, is that if a student lives with an adult who has accepted responsibility for the student and provides the student a fixed nighttime abode, then the student is a resident of the district in which that adult lives, as long as the student is not living with the adult for access to your educational programs. Notably, if someone comes in to register a student under numbers 2 through 4 on this list, but they don't have the adequate documentation to establish residency under one of those 3, you still need to analyze whether the student falls under the catch-all under number 5. So regarding Allison and our little twist, remember that I said that Allison is living with her natural or adoptive parent, her mom. And although I said many times on our previous slide that there are circumstances in which a student cannot move into a district solely to access the district's schools, a parent or guardian can move to a district specifically to access the educational programs of the district. People do this all the time. What matters is whether the student lives with the parent or guardian in the district. That could be in an apartment or a home of their own, like Allison here, but it could also be that the student and her parent or guardian are doubled up in the home of someone else, like a grandma, as long as the parent or guardian and the student live together in the district. Their intent doesn't matter. Now, one thing to keep in mind, too, is that a student who is over the age of 18 or who is emancipated also can move into the district, even to live with a family member or a friend for the sole purpose of accessing the programs of the district. So if a student turns 18, I've had it happen where that kid decides they want to come live on someone's couch to attend your school for their senior year. They can do so as long as that student is actually residing on a fixed and regular nighttime basis in that home within your boundaries.
Okay, so now what happens if Allison does have an IEP? Let's still assume that we have no facts suggesting that she might be homeless. Does that change our analysis? So let's look at what the school code says about residency for special education students. And it may be surprising that the requirements actually look a little bit different. Every once in a while, this does lead to a different outcome. So when a residency situation looks a little less than straightforward, it's important to start by asking whether the student has an IEP. Then you know which of these provisions we need to be looking at to determine whether or not the student is a resident. For special education students, generally the question is looking at who has guardianship over the student, as opposed to for general ed students where we were looking at custody. So residency is determined by the parent's residence when the parent has guardianship of the student and lives in your district, or if an individual guardian has been appointed by the court and lives within your district. Additionally, some situations where this comes up less frequently, but if an Illinois public agency has legal guardianship and the student resides either in the home of the parent within the same district, or finally, if the court has ordered residential placement, but the parents retain legal rights or guardianship and have not been subject to a termination of parental rights. In any of those situations, then the parent's residence determines which school district the student should be assigned to. On the other hand, where the student lives determines the school district where the student resides when the student is 18 years or older and no legal guardian has been appointed, the student is legally emancipated, a parent has legal guardianship but the location of the parent is unknown, an individual guardian has been appointed but the location of that guardian is unknown, or finally, if an Illinois public agency has legal guardianship and the agency or a court has placed the student residentially outside of the school district where the parent lives. The key here is the primary difference is that if the student is living with someone other than the legal guardian. If it's a general education student, that person might have legal custody for school residency purposes if the living arrangement is not to have access to your schools. But if the student has an IEP, school residency would continue to be where the parent lives, unless that third party has court-ordered guardianship. So we'll look at that a little bit more with our hypotheticals in a few minutes.
Okay, so we are now going to get into some of the red flags that you might see in the registration process that might tip you off that a student is not really a resident. And we've got those listed here and are going to do a deeper dive with some examples into what things to look for if those flags do appear. Now, we'll say that we all have heard of the scenario where you might have a neighbor or a parent call to give a tip to say, I don't really think this family lives in the district for whatever reason then that they give. But in addition to those tips that districts receive from time to time, if you're also asking the right questions at the time of enrollment at the registration process, you will be able to spot these flags. If you're asking basic questions on your enrollment forms, like where do you live? Do you own other properties? Who owns the home that you live in? Who else lives in the home with you? Does your child spend any time or any nights in any other home on a regular basis? And if so, where? Those types of questions may tip you off to the fact that a parent may have or own multiple properties, or may be doubled up with another family, or may have a scenario that could give an indication that the student is not really a resident. Now, these instances in and of themselves don't mean that a student is not a resident, but by having these flags and then by having thorough enrollment forms or affidavits at the ready to be able to ask even further, more detailed questions to really get at what the specific living situation is of the student and the family can really help you to assess whether or not this is actually going to be an issue and something that you would need to further investigate. When you do get such a red flag, in addition to having those thorough affidavit forms and enrollment forms that you can get additional information from to ask some of these different questions, additional tools that schools often use in conducting a residency investigation will include things like conducting background or records checks, interviews or home visits with the family, or doing actual surveillance to see where the students are coming and going. So these are some different ways in which and strategies to kind of have a full investigation if you're going to ultimately make a determination, or to help you make that determination as to whether or not a student is a resident or not. We today are going to be focusing not so much on the strategies and tips for conducting those investigations, but are rather going to be focusing on the substantive issues to keep in mind for making the assessment as to whether or not a student or family actually is a resident of your district. But we did want to note these. We often spend a lot of time with districts and administrators, whether giving presentations or just on the phone, and working with you to help identify what additional steps to take in your investigation, or what types of steps to do first or second. And so those are certainly things that you should reach out to your legal counsel and get assistance with. In addition, I mentioned the affidavits and enrollment forms that can be extremely helpful in having, in districts having at the very beginning of the registration process. That is something that you may be able to get from your legal counsel. I know us at our firm offer a residency toolkit where we have a number of affidavit forms that a lot of districts use, and some instructions along with them to help really guide you in that process to make sure you're asking the right questions. Before we dig into what some of these examples might be when you may have an indication that a student or family might not be a resident, we did want to take a quick note to discuss some timing issues. And this is another reason why prompt and thorough investigations are very important. So remember that if a student has ever attended in your district, whether they're a currently enrolled student or whether they attended your district previously, the previous year, and you're assessing residency eligibility again prior to the next school year. If the student's ever attended your school, you must give the student due process rights prior to disenrolling a student due to a determination of non-residency. So that includes giving the student a 10-day notice letter that you believe they are not a resident and the amount of tuition due, and offering them an opportunity to request a hearing. And then if you go to a hearing, you'd want to make sure that at that point you have all the information you need based on your underlying investigation to be able to present the reasons why at the hearing you believe the student is not a resident. If the student has not been enrolled in your school previously, then they do not have those rights to a hearing, and you can just make a determination that they are not a resident. So this is why it's so imperative that you try to identify those red flags at the time that a parent or other adult attempts to enroll a student in school full time. Because if you determine at that point, based on those red flags and gathering any other additional information that you can, that the student is not a resident, then you can simply determine and inform them that you've made that determination, and then they do not have to be afforded a hearing. Another quick note on timing is that if you do make a determination that a student is not a resident, but have determined that they have become non-resident during the school year, the school code allows them to remain a resident or to continue to attend your district tuition free through the remainder of that school year. So this is important too, because if it's during the school term, even if at the beginning of the school term, and you make an assessment that and you believe that the student may not be a resident of your district, it's important to include in your investigation the question and issue of whether or not the student has been not attending or not been a resident of your district even prior to the start of that school year. Because if that's the case, then you would be able to, upon a hearing and a determination, decide that that student can no longer attend school even through the remainder of the year if there's a finding that the student actually hasn't been a resident even prior to the start of the school year.
So now that we have covered the general rule for residency for both general and special education students, let's go through some scenarios to see these rules at work. Let's start with Lucy. Lucy is a student who is registered as a general education student at your school during her freshman year. In her sophomore year, you receive an anonymous tip that Lucy actually lives in Chicago. You ask a residency officer to conduct some surveillance after school one day, and sure enough, you see Lucy picked up at school and driven to a home just inside the edge of the Chicago city limits. So you call Lucy's parents in for a meeting. And at that time they say, well, yes, we do own that home, and we do use it sometimes for things. But we also own a home in your school district, and that's where we really live, so we are residents. Is Lucy a resident of your district? And what more might you need to know to find that out? Well, we all know that simply owning a home in your school district is not enough. School residency in Illinois is not based on property ownership, but rather on where the family lives on a fixed and regular nighttime basis. As an initial matter, for those of you who are using the Franczek toolkit of residency and homeless forms that Amy mentioned, you may not have been blindsided by the fact that Lucy's family has two homes, because, as mentioned, we advise that on your general residency form that you use for all students, you ask questions like whether the family owns or stays at more than one property. And that can be valuable information that you can use to follow up with additional questions to a family that may have prevented Lucy from being enrolled in your school district in the first place. And that's important not only for the fact that if Lucy's really not a resident, she's been receiving tuition-free education in your school district for the past year, but also that if we have to move Lucy mid-year, it's very disruptive to her schooling as well. And also it can be very challenging for families who are faced with a high tuition bill. So we do hope that you're asking that question at the outset. But if you didn't and you find yourself in this situation, you now will need to determine where Lucy lives on a fixed, regular nighttime basis, at the home in your district or at the home in Chicago. To do that, you're going to use many of the tools that Amy just mentioned for investigations, including surveillance, interviews with Lucy's parents, and depending on her age, Lucy, and almost certainly a home visit or two to the homes. How do you conduct those home visits? Well, we do have in our residency toolkit a form that can be used that can just be filled out during those home visits. But also, one thing I like for schools to consider is how do you announce those? We need to strike a balance between ensuring that families aren't blindsided by totally unannounced home visits and that they have some expectation of privacy, but also without tipping off a family that we're going to be doing a home visit on a particular date and time. So I generally prefer for schools to notify parents, maybe even in their residency enrollment forms, that they can conduct a home visit at any time, and that way parents aren't being blindsided by that if it happens. But you're also not, you are retaining some element of surprise. You're not telling them we're coming at a particular date and time. So you collect all that information about Lucy's situation based on your investigation. How do you make the determination about which home is the one that Lucy is living in? Well, Illinois courts have for a long time held that intent is the critical question in determining residence for students. And so in these cases, what courts would be looking at is which home is the one that the family intends to make their long-term permanent residence. Now, a person's acts are given more weight in this process in their declarations. So it's not going to be enough that Lucy's parents say, well, the home in the district is our home. We're going to be looking at their acts. And we're going to be looking at both their physical presence in the location and also, again, that intent to make that their permanent residence. Now, a person can't have two residences for purposes of student residency. A person's residence is the place where the person actually lives and where it's their true permanent home. And even if they're absent from it from time to time, it's the one where they have the full intention of returning. And if a student lives in multiple properties, courts will look at which one is the home base for that student when determining their residence. So those are some of the factors that you're going to consider. And let's say for our sake that Lucy's family is really just using that home in the school district as a kind of landing pad for school-related activities. So they are maybe they're staying there a couple nights a week when it's more convenient for getting Lucy to school, but in the most situations, they are using that home in Chicago on the weekends and on holidays and things like that. We're going to feel pretty confident that Lucy is not a resident, and so we're going to move forward with our residency disenrollment process.
Okay, next situation involves Joy. Joy comes to register with her father and her grandfather. They tell you they are all living in the grandparents' house in the district and present documentation to show that Grandpa owns the home and Dad receives his bank statements there. And so it looks like we have a situation where there's shared housing going on, and it's really critical here to have that paperwork filled out completely so you have a good understanding of that living arrangement. Some of the questions that you want to ask in a situation like this: where did the family move from? When did they move? Why did they make that move? How long do they intend to stay? And we're collecting this information because our concerns fall into sort of two different buckets. That yes, it's possible that this family is living together with the grandparents and the parents and Joy, but it's also possible that one of two other situations is happening. One is that Joy and her dad are not really living with the grandparents, but just want to use that address so that Joy can attend your school. The other situation is it's possible that Joy and her dad are living with the grandparents because they're homeless and they're doubled up because of financial hardship. And so we want to be asking those follow-up questions to determine which of the three situations is actually occurring. As we'll talk about more later, it's your job to ferret out if the situation is a homeless situation, even when the people coming to register don't use the word homeless. And so asking these questions and trying to determine, yes, is this a situation where the family is living together because that's the choice, or is that a situation where there's some sort of financial hardship or crisis that has necessitated moving in with another family member? If possible, you want to have Dad and Grandpa fill out those affidavits separately. That way, if you can catch at the beginning if there are any inconsistencies, you can follow up with additional questions. And sometimes in situations where families are doubled up or sharing housing, you really do need to do some surveillance or a home visit to understand what's going on and whether or not, number one, the student and the parent are indeed living there, and number two, if it is possibly a homeless situation. So gathering that information up front can help you understand what's really going on when a family comes in and says that they're sharing housing with someone else.
Another issue that often presents itself with some sticky residency issues or questions can be when there are divorced or separated parents. We've seen many times when a student who lives with one parent most of the time, but the student wants to attend school where the other parent lives. Now, essentially, the student needs to live with one of the parents at least half of the time to access that parent's school district. Sometimes a court order or parenting agreement will lay out what the arrangement is. It'll say that they potentially live or that they live with each parent 50% of the time. And in reality, it's possible that they do actually live with each parent, split up the week or split up the weeks or the months on a 50-50 basis. But there's also times where even though a court order or parenting agreement may lay out something in that way, the reality is inconsistent with what the agreement says. So again, what can be helpful here is, in addition to reviewing any parenting plan or court order that a parent provides that lays out what the living or custody arrangement is, we really recommend also having a specific affidavit or enrollment form questions that ask questions to find out where students are actually living and how often and on what days, so that you can get this additional information. This can be also very helpful because if there is a situation where legitimately a student is living pretty much split 50-50 between each parent, it may initially present itself to you as a residency concern, but it may actually, the student may legitimately be having that living arrangement and still be legitimately attending your school district. So having those additional follow-up questions in your enrollment forms can help tease that out so you don't waste administrative time on conducting an investigation and only to find out or make a determination that this is probably a legitimate situation. So here in our example, let's say that Brian's parents share custody, but the order says that dad makes all educational decisions. So how does that come into play? Well, again, looking at this, it's a pretty easy analysis if only one parent, let's say, has legal guardianship or custody, because in that case, the district in which the parent having legal guardianship or custody resides is the resident district. When both parents retain legal guardianship or custody, the resident district is the district in which either parent who provides the student's primary, regular, fixed nighttime abode resides. Although families can only elect a resident district one time per year, so they can't bounce around during the school year. So if this parents share custody and the student spends half of their time with one parent and half of the time with another parent, and parents live in different school district boundaries, the student can legitimately be a resident of your district in that instance, so long as they are not bouncing around during the school year and they're legitimately spending about half of that time there. Now, this rule falls within Section 14 of the school code, which specifically applies to students receiving special education services, but this rule is generally applied to general education students as well. Another thing to keep in mind, now, we've recently had an amendment to the Illinois Marriage and Dissolution of Marriage Act that calls for parents to develop a parenting plan that includes, among other things, a designation of the parent who will be designated as the parent with the majority of parenting time, essentially for school residency purposes. So the law says that for school residency purposes, the parent with the majority of the parenting time is considered to have legal custody. These parenting plans are also to include the child's residential address for school enrollment purposes. But essentially, it really needs to be the address of the person and the parent with the majority of the parenting time. So what we now often see in cases where there's divorced or separated parents is that there is some sort of parenting plan or other agreement that's presented to the school. And the key is to look at that to see who is the parent with the majority of the parenting time. And that really then should be the person that's designated as the parent custodian for school residency purposes. There are concerns sometimes where the parenting agreement may say one thing and then the actual reality of what you believe is actually happening may be different. So that's a red flag where then you may want to follow up with an investigation. Likewise, if the parenting agreement says that one parent is the parent with the majority of the parenting time, but then it designates a different address for school enrollment purposes, schools don't have to just take that at its face, but can still fall back to really ensure that it's the parent with the majority of the parenting time, maybe the one that's designated for school residency purposes, and continue to follow the same principles that we are discussing today in terms of determining whether or not a student is actually a resident of the district. So bottom line with these situations is that, especially where you have divorced parents with joint custody, districts should really closely review any applicable parenting plans and consult with legal counsel when there's any conflict that arises between what the parenting plan or court order says and what a district believes is the student's actual living situation.
So our final red flag that we're going to be talking about with respect to general residency deals with third-party residency. And we're going to have one scenario that talks about what to do with general education students and one that talks about special education students. So first, let's talk about Robert. So Robert comes to your school district with his grandma, and grandma comes in to fill out the paperwork for enrolling Robert in school. And obviously grandma is not Robert's natural parent, and when you probe further, grandma is also not Robert's adoptive parent. And thinking back to your list of 5 definitions of legal custody that we talked about earlier, you work your way through each of those scenarios and you determine that none of them really fits. There's not a legal transfer of custody or guardianship or any other paperwork that would show that mom has given up the rights with respect to Robert. And so really what you're dealing with here is just a traditional third-party residency situation where a student is being registered by someone other than their natural or adoptive parent. Now, in my mind, this should always be a red flag for you. Now, that does not mean that you aren't going to believe grandma and Robert as to their situation, but it's going to mean that you're going to want to collect more information to determine what's going on here. Because if you think back to our 5 definitions of legal custody, this is a situation where it's really important, number 1, where is Robert actually living? And number 2, what is the purpose of this living arrangement? If Robert is not actually living with grandma all of the time, that could be a problem. Again, we're not going to let him just use grandma's house as a launch pad for attending school. It needs to be his home base. And also, it could be an issue if the reason that Robert has moved in with grandma, even if he really is living there 100% of the time, if he did so in order to access your schools, that's a problem under the law, because you cannot have a third-party residency situation like this with a general education student where the only purpose is to access the schools. We're going to sound like a broken record a lot today, saying affidavit, 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 but this is why I highly recommend that anytime you have a student who's being registered by someone other than their natural or adoptive parent, that you use an affidavit at the moment of the point of first communication with the person enrolling that student. You are going to have that person complete an affidavit that's specifically tailored to that situation. And the types of questions you're going to be asking on that affidavit are, what was the purpose of the move? How often is Robert actually going back to stay with his natural or adoptive parents instead of with grandma? Who's making financial decisions and has financial responsibility for Robert? Who's making educational decisions? There's a laundry list of questions that you should be asking in these circumstances. And in all of those cases, you are going to be looking at, number 1, are they actually staying there full time? Are they really living where they say they do? And also, has Robert just come with grandma in order to access the schools? The only way you can possibly know, you're not going to be able to have a crystal ball or become a mind reader. The only way you're going to know the purposes of the move and whether or not Robert really qualifies for being with grandma enough of the time is if you ask those questions. So you need to really be focused on those things. And I know that from experience that we have a number of school districts who have our affidavits, but sometimes they feel a little bit uncomfortable using them. A lot of times these are building secretaries who are on the front line who don't necessarily feel as comfortable with knowing, why am I asking all of these questions of these people? And so we do really recommend, number 1, making sure that they understand why it's important. You can share the recording of this webinar with them after the fact so that they can hear straight from us about the reasons that we think this is so important. And then also we do encourage you to consider offering pointed training, preferably involving real-life scenarios where your frontline people are being given an opportunity to implement the affidavits and the forms so that they feel confident using them when they have someone walk in the door with a unique situation.
Okay, so let's say we have Carlie, and she's really in the same situation as, who did we just have, Robert. But she's a student with an IEP. And actually, this situation is easier. We don't have to answer all of the more complicated questions about how often does she live with grandma, why is she living with grandma, is it because she wants to attend that school? The answer is grandma is not going to be the residence we're looking at unless she has court-appointed guardianship. Unless the court has appointed grandma as Carlie's guardian, where her parents reside is going to be her school of residence. And so for students with IEPs, it is a little bit more straightforward for these third-party residencies. We don't need to delve into all those questions. We need to figure out where do her parents live, because that's still going to be the school of residence.
So we briefly wanted to just highlight for you the process that's used with respect to residency if you have collected enough information that you have a concern that a student who has already been enrolled in your school is actually a non-resident. It's much easier, as was mentioned earlier, if the student has yet to be enrolled. You can basically just say, sorry, you can't enroll. It may be as simple as just giving them a letter saying that. But when the student has been enrolled, they are offered due process under the law. And the process for residency hearings has changed somewhat in recent years. This is a layout of what it looks like today, and we're not going to go into detail about this process, but one of the most important things is the addition of an appeal to the Regional Office of Education, which is a new layer of review that we haven't really seen that it's been used a ton, but we have seen it being used, so you should at least be aware of that change.
Briefly, before we move on to homelessness, we'd be remiss if we failed to mention the important limitations that come into play where students are immigrants, including when they're undocumented. ISB, as well as the Supreme Court, has made clear that the immigration status of the parent and the child has no bearing on the rights of the student to enroll in school. The laws in Illinois and the United States guarantee all students, including undocumented immigrant students, access to a free public education through grade 12, regardless of immigration status. This requires every district to guarantee all immigrant students equal access to the full range of programs and resources. Notably, the law also prohibits any action that might have a chilling effect on the right to access school. Some things that might have a chilling effect include asking about the immigration status of a student or parent, or requiring parents or other adults to provide information about their status, or requiring specific documents that would result in requiring proof of legal presence, such as a social security number or Illinois driver's license. And we do see some districts still having on their list of required documents a driver's license or other state-issued identification. And we really recommend revising that so that there are other documents that could be provided and some flexibility there for parents to establish their identity, which is really what you're looking for, without it having to be something that would only be available to someone who is legally in the United States. If a family does not have the documentation that you're looking for, you do want to try and be flexible and creative to figure out how do we do the two things we're trying to do in our registration process, which is one, establish that the student and the parent are who they say they are, and then establish that they live within your district. And so it doesn't always have to be a driver's license and a lease or a mortgage. We can look at a lot of different creative ways to get to that information with different documentation. And sometimes a home visit will be a necessary part of your tool bag there to figure out how we can establish residency for families that might not have all of this documentation.
Okay, so let's switch gears now and spend the rest of our time talking about homelessness. We use this photo here because we think it's very important at the beginning of this discussion to be mindful of stereotypes of whatever it is that people may commonly think homelessness is or looks like. In reality and under the law, any family could become homeless, for instance, if they are temporarily living with a friend because their house burned down, even if they are middle income, upper middle income families. So it's always important to keep these key factors for homelessness in mind. Is the family sharing housing due to loss of housing, economic hardship, or a similar reason, which is commonly referred to as being doubled up? Or is the student otherwise not residing in a fixed, regular, and adequate nighttime residence? If the answer to either of those questions is yes, then you may be dealing with a homeless or McKinney-Vento eligible student. So a quick reminder of what it means if a student is deemed to be homeless. So first, you must immediately enroll. And we really mean immediately here. You cannot pause to investigate to see if they really are homeless, but that student must be immediately enrolled, and then you ask questions later. So not only does this apply to any student who is identified as homeless, but any student about whom you receive any facts that suggest they might be homeless. So that means that any facts that suggest that the family is sharing housing because of loss of housing or economic hardship, or that the student lacks a fixed, regular, adequate, or nighttime abode. Once you've enrolled the student, you then must provide the student a notice of their educational rights, connect them to the school or district's homeless liaison, and help connect the student with transportation and other services as needed. You may also be required to sign a statement verifying homeless status for a family experiencing homelessness in order for them to be able to obtain a free birth certificate. We want to note here, while we're not going to be able to go into detail on this today, there is also a very different dispute resolution process for homeless disputes, which is outlined in procedures provided by the Illinois State Board of Education. We're sure that most of you are familiar with this, but if you do, or if you are looking for a copy of those procedures, feel free to reach out to us and we'd be happy to send you a link to those. The most important thing here to keep in mind is that you must sensitively identify homeless students. Districts have an affirmative responsibility to identify all homeless students, and the staff should be trained to identify common signs of homelessness. In most instances, a student or parents are not going to come out to say that they are homeless. So being able to identify common signs, including that a family might be doubled up due to a lack of housing or other economic reason, is something to double check, especially for any family that's sharing housing, to rule out homelessness. So a homeless student can attend any of the following, and it's important to keep in mind that this is the family's choice. They have the choice between attending the school in which the student was enrolled when permanently housed, or the school in which the student was last enrolled, both of which are referred to as the school of origin, or they can attend any public school that non-homeless students who live in the attendance area in which the homeless student is living are eligible to attend. So either that school of origin or school of attendance area. So with these factors in mind, we're going to now look at some specific case examples.
So let's start with Emma. And just so you know, many of our hypotheticals today are based on recent decisions we here at Franczek obtained from the regional offices of education and intermediate service centers. So we're hoping to give you some insight into the latest and greatest from the decisions in this realm. So let's say that in April, Emma was identified as McKinney-Vento eligible by your school district because of loss of housing. Emma and her mother moved from another district into Emma's grandparents' house, which is in your district. So she transferred to you close to the end of last school year. Now, this school year has begun, and let's say that in September, you learn of an incident outside of school district boundaries involving Emma. And through your investigation into that incident, you learn that Emma and her mom have purchased, or her mom rather, have purchased and is residing in a home outside of the district with Emma. So first of all, my question is, do you have to wait 18 months from when Emma came to your district to move forward with any dispute resolution? It hasn't been 18 months here. State law provides that when a child is doubled up, when a child and her family are doubled up and sharing housing because of a loss of housing or economic hardship or other hardship. So when they're doubled up, they're homeless, they're living with somebody else, that a school district can, after 18 months and annually thereafter, conduct a review into whether that hardship continues to exist. So at that point, what you're really looking for is, they're still living together, but it's been 18 months, so at what point are we going to stop calling this a homeless situation and start calling it just a choice of living together? But here, Emma isn't still doubled up, right? So Emma's now alleged to be living with her mother in a home that's owned by Emma's mother outside of the district. So that 18-month provision doesn't apply. Schools can always look into a family situation if they learn that a family that is registered or registering as homeless is actually living in a fixed, regular, adequate abode. You don't have to wait those 18 months in order to do that due diligence, and indeed you shouldn't. We do recommend that you investigate these things early and often if you have any reason to believe that a family is not living in an inadequate or unstable environment anymore. So, okay, here let's say you have done the informal mediation for Emma, which is required by the law, and at that mediation, Emma's mom says, well, my parents are assisting me with payments for the house, so it could end at any time. It's not fixed, in other words. So is Emma homeless? The district in this case had a bunch of documents showing that Emma's mom was the owner of the house, that they have some documents showing that the family was there during an incident where the police were called, and other documents showing that mom actually owned this address since April of this school year, so about a year after she initially was identified as homeless by the school. The family in this case did not dispute the ownership of the home or the fact that Emma and her mother resided there. They only said that the grandparents were there too and that they were helping with the money. And the Will County ombudsperson here determined that this family had a fixed, regular, and adequate home and were no longer McKinney-Vento eligible. So this decision is important because it helps us understand that a family's situation can be fixed even if they are receiving financial help from someone else. And if you think about that, that makes sense. A lot of times people are receiving help from someone else to pay for their housing. That does not in itself render that family homeless.
Okay, another issue we see when there are disputes is which district can the student or the family choose to enroll in as a homeless student? What is the school of origin? And that was addressed in another recent decision from Lake County, and we'll talk about a hypothetical student, Willa. And so let's say Willa enrolls in your school for the 2017-2018 school year using her aunt's address. And Willa and her aunt say that Willa is living there with her aunt. In April of that school year, you get a phone call from somebody else saying Willa is not living with aunt and instead living with mom at her grandparents' house, which is outside the district. So you start to investigate. You look back at the iPad data because the student was issued a district iPad, and so you can look at the location data, and she has been using it outside the district on a regular basis. The data goes back to January. And for that entire time period, she's been using it at the out-of-district place. You also go back and you find out that Willa previously attended a private school that's located near where the grandparents live prior to enrolling in your school. Looking at her registration documents, you find that mom actually made a comment that she didn't want Willa to go to the school where the grandparents live because it's not very good. And that mom and the aunt gave conflicting statements regarding the reasons for Willa's move into the aunt's address at the beginning of the year, or when she moved. And then you find out in April of the 2017-18 school year that the aunt actually left the apartment altogether. So you do some additional research and you learn that Willa's mom and dad have been using grandparents' address as far back as 2007. You talk to the bus drivers that pick Willa up and find that Willa and her mom have been sitting in a car outside the bus stop, which happens to be right in front of the aunt's house, which seems suspicious. And you talk to the apartment manager who says that, yes, the aunt lives there and that Willa visits from time to time. You also have some returned mail from that was attempted to be delivered to Willa at the aunt's address. When you confront Willa's parents, They say, well, Willa is living at the aunt's house, except when they're confronted with the iPad data, they say, well, she moved out in January. So what do we do at that point? At that point, this looks like a straight residency issue. We don't really have any indication that there may be a homelessness situation happening. And so in this case, the district did use the residency process and prevailed, so the family disenrolled. However, the parents then went to the ROE and said, hey, we're actually homeless and we need help. And the ROE reached out to the district and said, district, this family is homeless, you need to re-enroll them. And the district, of course, because they're required to do so, did re-enroll the students immediately. They wanted to then dispute the process because they didn't believe Willa had ever actually lived with the aunt in their district. And so it shouldn't have been a school of origin that would be a choice. Even if the family is homeless, if she never attended school or lived within that district, then it wouldn't be a school option. So they went through the dispute process, and ultimately the ombudsperson did agree that the family was homeless. That wasn't actually disputed. And he noted that the family didn't provide any proof that the student had lived with the aunt at any time, but also the district hadn't provided any proof that she didn't live with aunt at the beginning of the school year. And since we're at a homeless hearing, it is the district's burden of proof as opposed to the parent's burden. And so he determined that the student had started the year appropriately within the district. Interestingly, the ombudsperson went on to say that since the family was in fact living with the grandparents outside of the district, that is where the student should attend the following year. I don't think we could put any stock in that. At the end of the day, given that the ombudsperson found she was properly enrolled in the original district, if she came back the next year, I think you'd have to say that is her school of origin if she's still homeless. One other important takeaway, though, is that a key problem with the district's case is the lack of real proof from the beginning of the school year. And so all of the documentation, all of the things that were suspicious had happened in the spring, and there was no way for the district to really show what the living situation was back in August and September. This puts districts in a hard situation. You probably don't have the capacity to investigate every doubled up or every third party living situation that comes your way, and even doing so could be considered unfavorable treatment of homeless families. On the other hand, collecting that information early in the year is really critical when you get to a dispute process, whether it be residency or homelessness. And so you want to try and balance gathering all the information you can at the beginning of the year. Okay, and we'll do Bobby next. This is a decision from Will County. And Bobby's been a student in your district for a while. The parent enrolled in March of 2015 using a lease within the district's boundaries, so not a homeless situation, living with a parent in the district. But then in 2016 and again in 2018, the parent claimed to be homeless due to economic hardship, loss of a job, and inability to pay rent. The parent acknowledges that she and Bobby have lived with a friend in an out-of-district address since May of 2016. And it's now August of 2018. She agrees that the residence is nice and it's livable, it has 3 bedrooms. However, she claims that the friend could ask her to leave at any time and she doesn't know where she would go. So is Bobby still homeless? In this case, he did previously live in the district, and so that is his school of origin. Mother lost the job, couldn't pay the rent, and so had to move in with a friend outside of the district. And so I think reasonably was homeless at that time. And your question is now, going on 2 years later, is the student still homeless or has the situation become fixed and adequate? And here the ombudsperson said the student was not homeless. His family had lived continuously without interruption at the out-of-district address. The residence was adequate. There were enough bedrooms. And although the family said the friend could ask them to move away at any point, the ombudsperson said a possible future event cannot be a basis to find that this family is homeless. It was just too speculative. If the next week the friend did in fact kick them out, then we'd be back at the table trying to figure out what to do next, because the family could very well be homeless. But at that point, they've been living there continuously since 2016, and it did appear to be a stable residence.
So our last hypothetical, I'm not really going to dig into the meat of this very much, but I just want to let you know this is based on a case from West 40 Intermediate Service Center, and I just want folks to be aware, if you're in that jurisdiction, of the outcome of this case. So this was kind of a cut and dry case in the sense that the district didn't dispute that the family was homeless at one point, but they did have a lease for the family showing that eventually at the start of the school year, they moved in in an apartment, and that they were permanently housed. And after a little bit of back and forth on the evidence, the ombudsperson agreed that even though the family presented some evidence that they could become homeless in the near future, or that they had been experiencing some financial hardship, they were living in a fixed, regular, and adequate home since the beginning of the school year, and so they were not homeless and should be transferred to the school district where their home was located. But why I wanted to highlight this is that the ombudsperson didn't stop there. There was some commentary regarding how the district communicated with West 40's homeless liaison prior to the hearing. None of this really had anything to do with the case, doesn't necessarily belong in the decision, but I at least want people in this jurisdiction to be prepared if they go to a hearing in this case, that there often will be extraneous details and criticism that they should be prepared for, even if they prevail. However, the real great takeaway, and our own Kendra Berner handled this case, is that we prevailed on this case in West 40, which is a victory that we did not often get to say in many years ago.
All right, we're running low on time, so I'm going to skip over here our investigations. Like we've talked about throughout, collecting that information early is really critical, and then taking those next steps when you see red flags. I see we have a question on the side. So for a special education student who may be homeless, does the parent's residence still control? So if the mom lives out of district through government assistance, but the student bounces around in the district and with mom. Yeah, so I think we're still going to look to where mom is living, and if mom is homeless, then the homeless piece of it would inform whether or not your school was the school of origin, but we'd be looking at where mom is living.
And we've done our best to try to issue spot here for you the various issues that come up. And I know we've said it throughout the webinar today, but we do want to stress that a lot of times these circumstances play out in real life for you at your districts and can present nuances that we cannot anticipate, and that often then can really affect what would be the best way to approach a situation, whether it's in terms of investigation or whether it's in terms of how best to proceed in terms of that student's eligibility in your district. So certainly use your legal counsel in these situations and make sure that your frontline staff know when to refer something to your administration as well, so that you can make sure you're getting the support you need to help address some of these more difficult questions that you might face. So with that, we really thank you again for joining us today. We hope you found today's program helpful. If you're interested in learning more about our firm's Residency and Homeless Toolkit, or in receiving training at your district on how to use those forms, please contact one of us. Our next webinar, as part of our monthly education webinar series, will be on September 24th, where we will discuss homebound and hospital instruction. You will receive an email today with today's program's recording and presentation, as well as the link to register for our upcoming webinar. Thank you very much again for joining us, and have a great afternoon.